All right, hi everyone, and welcome to today's webinar. My name is Jason Q. I'm the Senior Managing Attorney at the DC Bar Pro Bono Center in our nonprofit and small business legal assistance programs. Thank you all for joining live, and for those listening to a recorded webinar as well. We're really excited to present a program today on intellectual property for entrepreneurs and nonprofits. This webinar is part of a well-established webinar series from the DC Bar Pro Bono Center. For those who want to visit our webinar archive, our website is lawhelp.org/DC/NPSB. On that homepage, you'll find our archive of webinars for both nonprofits and small businesses, including webinars on intellectual property, but also on any other business law topic under the sun, from starting your nonprofit or small business entity to employment law issues, to issues around contracts and insurance, and of course, like today, issues around intellectual property and other internet law or related topics. I'd like to do a brief introduction to our presenter today. We are very, very glad to have Amy Foust joining us from the law firm Wilson Sonsini. Amy is senior counsel in Washington, D.C. at the firm's technology transactions and intellectual property practice groups. I'll leave it to Amy to tell us a little bit more about her practice before jumping into the presentation. Just as a few housekeeping notes, the slides for today's presentation will be available in whatever format you originally accessed the presentation. And I will elevate questions to Amy throughout the presentation. So with that being said, Amy, I'd like to turn it over to you. Thank you so much for joining us today and for talking about intellectual property.
Thank you for having me, Jason. I'm excited to be here. As you noted, I practice in the Technology Transactions Group at Wilson Sonsini, so I am a qualified registered patent attorney, but my practice mostly focuses on helping people negotiate partnerships or arrangements with other parties regarding their IP. My understanding is that the DC Bar Pro Bono Center has been getting a lot of questions about agreements. So today, we're not going to do a traditional IP overview of different kinds of IP. We'll do a little bit of that to get started. And then I wanted to address some of the common concerns that are coming up around how we share and transfer IP and how we look at agreements that involve IP. So if you were hoping for a more traditional IP overview, I'd encourage you to go to the website Jason gave you. I also have that address later in the slides. And you can pull up other IP presentations that may cover different aspects or different information. And please do put questions in the chat. I would so much rather talk to you about things that are important to you and relevant to your businesses or your nonprofit operations today than to talk to you about random things. So please use the chat. And Jason, I'll thank you in advance for interrupting me as I go if there's anything we need to talk about. Of course, this presentation is for education only. It is not legal advice. And I think you'll see as we go through it that especially with intellectual property, so much of what you want to do is contextually driven. Depends on your circumstances, depends on what's happening in your business, but you really want to talk to someone about specifics for what you're trying to do and what your circumstances to make sure you get it right. So I hope this is helpful to you in getting oriented and thinking about the issues and understanding when maybe you need to reach out for legal help, but nothing here should be taken as legal advice for what to do in a particular situation. And with that said, we'll do a really quick overview of intellectual property. IP comes in different flavors or different types. So you'll see those darker boxes towards the left of your screen. Those are intangible intellectual property rights. There's nothing physical necessarily about them. You can't hold them or touch them. They're ideas or they're expressions. And so these are the things that we're talking about as opposed to an object that you sell or an asset that you own, a property, a real property that you own. These are things that exist in the realm of ideas or information. And that's what we're going to be talking a lot about today. Trademark is a source identifier. So a classic example is the difference between Pepsi or Coke. Both of them are sodas. But some people prefer the flavor of Pepsi or the flavor of Coke. And so it's important to them, the trademark is important to them because it tells them whether the soda that they're buying is going to taste like Coke or taste like Pepsi. So that's what we mean when we say it's a source identifier. It tells your customers where the goods are coming from and potentially conveys information to them about the nature or the quality or other aspects of the goods that they're buying. Patents focus on things or processes. So if we stick with the soda example, that might be about the machines that are used to fill a soda bottle, or even the formula for the soda itself. And patents, if you obtain a patent, give you the exclusive right to make, use, or sell the patent, the claimed invention in the patent. So a trademark protects the source identifying information. It keeps people from misrepresenting their products as yours. The patent can actually be used to stop other people from making the same product or using the same process, depending on what your patent covers. Then there are copyrights and mass work rights. These cover drawings or expressions of ideas. They don't cover the ideas or the information themselves. They cover the particular expression or layout or design. Examples here, if we're sticking with our soda context, would be advertisements or website copy. You can imagine that Pepsi wouldn't be happy if they spent a lot of time working up a really clever website that really engaged people and got them excited about the brand, and then Shaq Soda completely copied that website and used it for their own purposes. So the copyright protects the expression of the idea. We often think about it in terms of written work, but it also covers performances, it covers music, it covers photography, and those kinds of expressions or visual representations fall within copyright. The right itself in the copyright covers things like copying the work, making copies of it, distributing copies of it, making derivatives of a work, which could include translations or other modifications to the text. And so, again, trying to compare, the trademark is your source identifier, tells you where the product's coming from, the patent covers the thing or the process, and the copyright covers information, ideas that are being expressed in a specific way or presented in a specific visual way. And then there are trade secrets, which is a little different than the other kinds of IP that we've talked about so far. So trademark, patents, and copyrights can all be registered. You can submit an application to a government agency and get a certificate back that recognizes your ownership or your investment in those kinds of intellectual property. Trade secrets are not registered typically. And what a trade secret is it's information that is a secret. So it's confidential, other people don't have access to it or don't have it. In order to qualify as a trade secret, as opposed to any other kind of confidential information, it has to have value because it is a secret. And it has to be subject to active steps to protect its secrecy. And a really common example of that, again, if we're staying with the soda example, is the formula for Coca-Cola was not patented. It's never been released. It is held as a trade secret. And so by keeping it secret, by actively protecting it, by literally keeping the formula under lock and key, limiting the number of people who have access to it, they're protecting that as a trade secret. And so that formula is protected basically because of the efforts that Coca-Cola goes to keep other people from learning it. And again, the difference between a trade secret and confidential information more generally is that there are specific protections for trade secrets, so that if someone gets access to your trade secret, a consultant, someone who's providing services to Coca-Cola somehow gets access to this formula, if they steal that and use it for their own purposes, then there are specific remedies available for that because of the special protection that was given to your trade secret. We also have a couple blocks around tangible technology. these are things that we're going to talk about today, mostly as embodiments of the other kinds of IP. So even when we're transferring tangible items, we want to be thoughtful about what they might communicate about intellectual property or ideas that you might want to protect, and how to address that when we're building relationships or working with other people. I'm going to pause and just see if anyone has any questions so far.
Nope, good to go.
Awesome. Okay, so when you're thinking about IP, when do you need an agreement? You may need an agreement if you are giving or exchanging information or samples. Remember that your samples may embody your information or your intellectual property with another person or company. You may need an agreement if you need rights to use someone else's IP, or if you want to grant permission for someone else to use your IP. You need an agreement if you want to clarify a relationship. You're going to do work with someone and you want to make sure it's clear that they're working for you as a consultant and not an employee. You may want to clarify responsibilities or requirements as you're working with another party. And there's a long list of things that you might want to cover here. There are more, but typically you want to focus on these things like cost, quantity, timing, if that's important to you. Does it matter whether the work gets done in 3 months or 6 months or a year? Often, yes. What will be delivered? What specifically will be delivered? How will it be delivered? Is there a standard of performance? So depending on what your business is, do you need to meet certain regulatory guidelines? Do you need to make sure that you're meeting voluntary industry standards? Or do you have your own policies or practices that you follow that you want your vendors or your partners to follow as well? And then, of course, if you want to document the transfer of IP ownership. So if you are buying a patent, if you were buying a trademark, which you can do, these are transferable rights, you want to get that in writing so that it's really clear what was transferred, when it was transferred, and who it was transferred between.
Can I ask a question here? Sorry, you might be getting to it a little bit later on, but can you talk a little bit about the difference between like a freestanding IP agreement versus when we might see some of these considerations built in as provisions into other agreements or contracts or MOUs or other types of documents that might not explicitly be framed solely around intellectual property?
Yes, and we will talk more about that, but the short or simple answer is these can either be built into another agreement that has a different heading or title, or they can be standalone. You may want to do that one way or another depending on your circumstances. So for example, if you expect that you may need to transfer those rights pretty quickly to somebody else, you may want the IP ownership or the IP license handled in a separate agreement because it's easier to transfer that little piece rather than the larger agreement. Conversely, if the IP is really important to you, if that's really the heart of the deal, you either want to do those two separate agreements together. You want to make sure they're signed together so that you get the full benefit of the full deal, even if they're documented separately, or you want to incorporate them into one agreement. You just want to make sure that if the IP is really what's critical to you, that it's getting addressed with the rest of the agreement in time. You want to document the whole deal as you do the deal, as opposed to doing it piecemeal.
Awesome, thanks.
Ideally, all of these agreements, whichever kind you need, whichever step you're trying to go through in terms of clarifying your relationship or documenting IP ownership, ideally you want your agreement to be written and executed before you begin doing what you're doing. And people can stage agreements, so you don't necessarily need to enter into a license right away before you start working with somebody. What you might need is a confidentiality agreement so that you can talk about the intellectual property rights and what you want to do with them if you're sharing sensitive business information back and forth. Getting ready for that deal, you may need a confidentiality agreement And you want that confidentiality agreement to be written and signed, executed, before you begin sharing confidential information. And then if what you're doing is negotiating a license so that you can use someone else's intellectual property, the copyright license, you want to use their photograph, you want to make sure that your copyright license is written and signed before you post that photo on your website or use it in your advertising or whatever you're going to do with the photo that you're licensing. So here I say the agreement, but to Jason's point, sometimes agreements are staged. And what's important is that the agreement that's been written down and signed is covering what you're actually doing right now. And that's okay. In fact, staging agreements can be very beneficial. If you don't need a license, negotiating an entire license and maybe making upfront payments and doing other things, it can actually be very expensive and waste resources. If it turns out you don't need a license, or if you need something much simpler after some back and forth conversation than what you originally envisioned. So it's perfectly okay to stage agreements and may be very cost effective to do that. You just want to make sure that whatever you're doing is actually covered by the agreement that you have in place. Okay. So when we think about what you need and are your needs covered by the agreement that you have in place right now? For intellectual property, we want to think in terms of both restrictions and rights. So restrictions, by restrictions, what I mean is, does someone else have rights to stop you from doing what you plan to do? And there's two ways you can find that out. One is to proactively do searches and think about IP as you're using it. If you know you didn't generate it, thinking about it and working through those issues proactively. The other way is to wait until you get a cease and desist letter from someone and kind of see if that happens. I think a lot of startups and nonprofits operate under the we'll wait and see. The caution to that is if you have invested a lot of time and energy into buying signage, building out a website, building brand awareness, getting Yelp reviews for your business, building partnerships or funding sources, right? You've already applied to grant agencies under a particular name. If you later get a cease and desist letter, that can be tremendously disruptive. So rebuilding that brand awareness, rebuilding your following, if I go back and look for my favorite restaurant, right, my new favorite restaurant, and it's gone, or there's a new name for the restaurant in the place where my new favorite restaurant was, I may not recognize it. You may lose a customer because even though it's the same company, I don't recognize the name on the business anymore. So those cease and desist letters can be very, very problematic, not just because of the cost of paying any damages that they might demand, not just because of the cost of ordering new signage, new business cards, new letterhead, but also in terms of rebuilding the brand recognition, right? Or the cost of having to go back and refile paperwork and redo legal documents, everything from your incorporation documents to agreements you previously entered into. Getting all of that straightened out can be really disruptive to your new business. So I would encourage you, if you are launching a new product or using a new tagline, you can do trademark searches and look around and see who else is using similar trademarks or similar names, because whether they're going to send you a cease or desist letter or not, knowing that your name is not unique can also tell you that people may have trouble finding you and knowing that it's you as opposed to somebody else. So doing those searches is helpful for building your brand. It's helpful for avoiding later claims that can be very disruptive. So it's a good practice, not just when you start up your business, but anytime you introduce a new product name or, like I said, a new tagline, to look and make sure that there's no one else doing something similar who may be able to assert trademark rights against you. Copyright, my caution to you is just because someone posted it on the internet doesn't mean it's free to use. So we have access now to more materials than we've ever had. but you still have to respect the copyright underlying those materials. So if you copy a picture because it's really cute and you use it in your advertising or you use it on your website, you may get a phone call from the photographer or from the photographer's attorney demanding copyright damages or demanding that you take it down. And again, that can be very disruptive to a campaign, even beyond any damages, or if you're able to negotiate the damages down. So just being aware of these things, looking in advance, doing some planning around that so that you know what else is out there can be very helpful and avoid a lot of problems down the road.
Amy, can I add one quick gloss on that copyright point? Just from my practice, I have seen a real uptake in photographers, but also like media companies like Reuters, etc., like kind of scraping the internet for images that they might have taken or that they own, and sort of almost automatically sending cease and desist letters or demand for copyright damages to small nonprofits that might have copied and pasted those images onto their newsletter or onto their website. So I think with technology, it's getting easier for these entities to kind of find people who have been using their images in a way that wasn't possible before. And I think you're totally right. Being proactive and sort of training people on what they can use and what they can't, and sort of creating a process for clearing images is becoming more and more important, even for small organizations.
Yes, and I will mention also, because we're speaking to nonprofits as well as small businesses, that the fact that you're not profiting off it, that you're offering services for free, that you are operating in a nonprofit status does not change the copyright rules. And you've probably heard about fair use. Fair use is very limited. Start from the assumption that you are not going to fall into fair use of someone else's copyright unless an attorney tells you otherwise, because that really is the general rule. There's a very limited exception for fair use. You should know that you do not fall into fair use merely because you did not directly make money off your use. So even if it was for a for-profit business, you know, a picture about you participating in community service or something else, it's not something where you were directly using the image or the text or the song to sell your product. Copyright still applies. You probably do not fall within fair use. So do be mindful of that. On the flip side, you probably have intellectual property rights, and you want to make sure that you are securing those rights and limiting others' use. So one of those things is what I'm calling the underlying IP. So if you have trademarks, whether they're registered or not, if you have copyrighted materials that you've prepared, if you are sharing those with other entities or with other people, it can be helpful to have a simple agreement in place that says, I'm sharing this with you for these purposes. You may use our nonprofit logo only to do these specific things, or only in this country, or only for this limited campaign, right? Where you're selling products and we're going to get a share of the proceeds back. After that, I don't want you continuing to use it indefinitely. 5 years after you do your 10% of sales this weekend go to this nonprofit, you don't get to keep our logo on your website 5 years later. So we want to look at underlying IP that exists as you're coming into the relationship. If the relationship is more collaborative or service-based, if you're hiring, for example, a marketing company that may do interesting things with your logo as part of their promotional activities or as part of their marketing drive, you would like an agreement in place that says that you own those modifications, you own those materials, so that it's perfectly clear that you don't have to go get a copyright license from your own marketing company to do that, and that they don't have the right to continue to use those materials to generate work product for other clients. What they generate for you is yours, and you're going to keep it and own it. And if they want to go do really clever, creative things for other people, you probably are not going to get in the way of them doing that, but they're not going to use your materials to do that. Improvements to or derivatives of existing IP are a similar concept. there could be completely newly generated IP, right? The marketing company could come up with a tagline or something new that you've never used before. You would also want to own that. You would want to have clarity that that belongs to you. It's being generated for you. If you are working on product development, data and confidential information were not listed on my first slide. Technically, they are not intellectual property in the same way that copyrights and trade secrets and trademarks are, but they're important, and knowing who controls them, who can use them, how you can use them is really important. So if I hire a company to manufacture my product for me, I have a great idea, but I don't have a manufacturing setup in my garage or my small business front, and I have to go to a contract manufacturing organization. It's important that we agree on the data they generate, who owns it, who can use it. The confidential information they generate about the product and how it works and how it can be manufactured and what all the costs are for making that product. Who owns that? Who controls the confidentiality of that information? Even if we agree that it's confidential, is it confidential information that belongs to the manufacturer and they can use it for their purposes and they can decide whether to disclose it, for example, in patent applications or to other clients for comparison purposes? Or do you control that confidential information and you decide who has access to the cost information for your product or to the manufacturing data for your product, for example, about defect rates or failure rates? So those kinds of things, just being very clear about, even if we've agreed who's going to keep it, that it will be quote unquote confidential information, whose confidential information is it, who owes what obligations to whom in terms of how that information is managed. And you can see in that case, if it's the manufacturer generating it using their manufacturing line, it's not 100% clear from outside who should own that data and confidential information. Depending on who I'm representing, I can make the case either way, right? It's my product, of course I should own the defect information. On the other hand, the manufacturer is going to say, it's my process, it's my manufacturing equipment, it's my operation, of course I should own the information. And maybe you can both use it, and maybe you both agree that you'll keep it confidential as the confidential information of the other party. That's fine too. But having that conversation up front and making sure you're clear about who gets to use that data and for what purposes can be really helpful. Rights also can have different scopes. So you don't have to transfer all of a patent or all of a trademark at the same time. It could be, like I said, that you can use my logo for a short period because we're doing some kind of joint exercise. But then when that joint exercise, whether it's a marketing campaign or a joint awareness campaign or whatever it is, when that ends, I want you to stop using my logo. You're not going to continue to assert that you're associated with me or that I've approved of this particular activity or content after our joint work together is done. Place is a very common way to divide up IP rights. So maybe I'm going to use stuff in the US and you'll use it in Europe. And purpose. So you can use my logo for the purpose of advertising or launching or promoting our joint activities, but you may not use it to imply that I approve of or am involved in any other kinds of activities. One example, place where people often get in trouble with scope of use restrictions is with copyright, even if you've gone through the exercise of getting a copyright license. And that's gotten a lot easier. There's a place called the Copyright Clearance Center that covers a lot of very popular materials, where if you want to copy journal articles or journalists' work or even some photos or other things, you can go in and fill out a survey essentially on the internet about how you plan to use it, and it'll give you a price and you can acquire a license. The caution there is, even once you have a license, being aware of the scope of use restrictions on the rights that you acquired. So in copyright, you may get a different price and a different scope of license based on whether you're going to post the copyrighted material, for example, in a password protected environment where only a small number of your direct clients or your direct collaborators on a project are going to have access to it, or whether you're planning to post it on the internet in an unprotected way where anybody can get access to it without a password. Those are going to be different licenses with different costs. And so if you took a license for an internal protected distribution to a small number of people, and then you put it on your world-facing, completely public website, you may get a call from the copyright holder saying, you're operating outside the scope of your license. This is actually copyright infringement, and they're correct. If you're operating outside your license, that is potentially copyright infringement. Similarly with copyright, if you ask for permission to an excerpt and then publish a whole work, that can be problematic. And print versus electronic. So if, for example, you want to print out a journal article saying that your new device helps minimize wrinkles or whiten teeth, if you have permission to print 50 copies and hand those out at a trade show, that is not the same as having permission to send it to your entire email list electronically. So just being aware of what you actually license, what you actually have the rights to do is important. Okay, and with that said, coming back to this concept of, does this all go in one agreement or does it come into several separate agreements? When we're looking at the actual contract, the agreement, the written down agreement, we want to pay attention to the provisions, not the title of the agreement. One place where I see a lot of people get in trouble with this is if you have a physical product and you are going to a contract manufacturer, the contract manufacturer may include provisions in a standard confidentiality agreement that also say, if we make changes to the design or the formula you send us for costs or manufacturability, we own the modified formula. And on the one hand, that may sound fair if they made the change, if they created the modification. On the other hand, it's your formula that they're working off of. You're paying them for their services, presumably. And what that means is that if for some reason you wanted to move to a different manufacturer, you would have to change your formula. That original manufacturer now owns the actual formula that's been in production, that they tweaked for cost or for manufacturability. And so if you take it someplace else, you may be able to take your original formula with you, but your in-market formula may have to be reformulated because you can't use the formula that was created by your contract manufacturer. And if that's your deal and you're comfortable with that, because you got great pricing or because of something else, that's fine. What's important is understanding that if somebody hands you a confidentiality agreement and it contains an assignment clause that transfers ownership of certain aspects of the product to the other party, or that gives them ownership of certain improvements, it's absolutely irrelevant that what's across the top of the document is confidentiality agreement. Those provisions that transfer ownership or that create a license still apply, even if you thought you were only signing an agreement to keep information secret. So it's important that you read what you're given, and it's important that you understand that if it says something different than what the title says, we have to deal with what it actually says, not the title. So in that respect, some common provisions that you may see that relate to IP are assignments, which is a transfer of ownership. I'm assigning to you, I'm giving to you my rights in this intellectual property. And you may see language like agrees to grant and hereby grants. And that future looking language can be effective. So you may be assigning rights in potentially patentable subject matter or copyrights that haven't even been created yet. But you're saying, I agree on whatever principle based on who invented or created the work or what the subject matter is, that I will give you those rights when they arise. And of course, that can work to your advantage as well. You may see some manufacturing organizations that say, look, if it relates to your product, we'll assign it to you. And if it relates to our manufacturing line, you'll assign it to us. And again, depending on the circumstances, that may be a fine deal. It's making sure you understand what the deal is and that you're paying attention to what the provision says, not the title on the agreement. In contrast, when we talk about a licensing provision, we're normally talking about less than a transfer of the ownership of the entire asset. We're talking about some kind of permission to use. You may see confidentiality or non-use provisions. And again, the agreement may say confidentiality, but including assignment or a license. Or you may see a licensing or assignment agreement that also has a confidentiality or non-use provision. And what those typically do is impose restrictions on what can be done with information or materials that are exchanged under the agreement. In addition, or instead of a confidentiality agreement, you may see exclusivity or non-competition agreements. So maybe you're not going to work with any third parties to develop comparable materials, whether those are copyrightable educational materials or software to advance your purpose, or something patentable, right? That manufacturing formula. You're not going to work with anybody else to do that development work. Maybe for a time period, maybe ever. You won't start a competing company. You won't supply these materials to other people, or I won't order these materials from anyone else. It'll be a sole supply arrangement. So you can see paying attention to those can be very important. If you think you're signing a confidentiality agreement with a potential manufacturer, and what it actually says is that you will not order the materials under discussion from anybody else, that's a very different level of commitment than simply saying we're going to share some information and I won't share the confidential information you share with others. And then in many agreements, but also in IP, you may see limitations on liability. And so especially if the IP is not being fully transferred, or if you're making physical products, there may be a great deal of concern about if I give you the rights to do this and you cause some problem, you harm someone in some way with those rights, am I going to be on the hook for helping to make those people whole, or helping to undo those harms because it was my IP? And so often you'll see limitations on liability, or also indemnification clauses that allocate the risk and the costs of any harm that comes out of these arrangements. So getting into a little more detail on some of these, I'm going to go a little fast because we're running out of time and I want to get to some information at the back that I think you'll probably want. Actually, I'm going to skip these slides. These are in the materials. You can download them. These are just examples of when you want to use different kinds of clauses or provisions. This is not exhaustive, it's exemplary. And so the idea is if you're looking at an agreement and you're trying to decide if a clause belongs in the agreement you're trying to sign, you can think about, well, is that actually what I meant for this agreement to do or not? And again, these are not exhaustive. You can use licenses or assignments or any of these provisions in other ways, but it's to give you a flavor for how they're used or what they're typically trying to do.
Amy, can I ask one sort of common situation especially with assignments and licenses?
Yes, please.
Yeah, I think a lot of people are confused or have conversations around when to use one versus the other. So I'll have people come and say, you know, we're hiring a contractor to create some content for our website. Should we sign a license with them for that contract or for that content, or should we sign an assignment? And so can you sort of sketch out generally the strategy behind, if there is going to be a conversation about one or the other, how people should be thinking through that?
Yeah, thank you. So an assignment typically transfers all of the rights in the intellectual property. If someone is creating something for you, and again, whether it's that manufacturing formula or the marketing materials, your preference is probably that everything they create, they will assign all of the IP in it to you. If there's patentable subject matter, you own it. If there's copyrightable subject matter, you own it. I think it's great that people are asking you the question. I think a few years ago, it was more common for people to say, well, I hired them, so obviously I'm going to own the IP. That is not always the case. It is far preferable to write down what you're agreeing about the IP rather than relying on default rules. The default rules can be very confusing. They're different for consultants and employees in many states. They may be different based on what state you're operating in. And so if you and your business associate are operating in different states, there may be confusion about which baseline rules apply. But if you write down in your contract how you're going to share that IP, you avoid all of that. A license is typically transferring less than full ownership. So the example that I gave here is you have a trademark that maybe you've registered in both the US and Europe. You're selling in the US, it's going to be a while before you could get to Europe, but somebody contacts you and says, we'd like to sell this product in Europe. What you want to license to them is only the rights to use the mark in Europe. You're not giving them the rights in the US, which you're going to be using. And you're not going to give them rights necessarily globally if they're only going to be working in Europe, because what happens if next week you meet someone from Mexico who says, hey, we could sell in Mexico for you. You don't want to have given away more rights than you needed. So the license is more of a carve up that gives you specific rights that are less than the whole package of rights in the intellectual property. And I'll pause and see if there are follow-up questions.
Great, thanks. No, that's awesome.
Okay. You may also see both assignment and license clauses. So it may be that you've agreed to split up IP ownership in a certain way. So for example, if you're working with a web developer, they may say, look, the frame that we're using behind the website is something we created and that we use and modify across all of our client bases. You don't own changes to the frame. And in fact, if we're sitting in a conference room and you make a suggestion and we adopt it, you're going to assign the intellectual property related to our frame to us. Maybe that's okay if you're not in the business of web developing, right? They need to use their frame with other clients. Maybe that's okay with you. You may in the same agreement, however, clarify that if your web developer generates content that's specific to your company, or that uses your logo or your color scheme, that will belong to you. And they're not going to redeploy the same copy or the same marketing materials on other websites. And negotiating that can be a little tricky because sometimes the difference between the frame and the content is not as clear as you would think it should be. But sometimes you will see the marketing company will assign to you content related to your mark and your business, and you will assign to them any intellectual property related to the web design framework or to certain other aspects of their consultancy or their business. So you may see both. And then sometimes you'll have a cross license. So they own the frame, but you have global, perpetual, irrevocable rights to use it for your website. So you're assigning the IP to them, but you're always going to have the right to use it with respect to the website that they're returning to you. So you can see both an assignment and a license in the same agreement too. And you can see cross licenses and cross assignments in the same agreement. So,
Great,
okay.
Thanks.
And I understand there's also been questions recently about collaborations. And collaborations raise all the same issues. And I think sometimes we get stuck in a mindset that we're working together, so we'll just share. But talking about what that sharing means can be really important to avoiding disputes later. So in this case, in most cases, I wouldn't think of the contract negotiation as adversarial. It's not about who gets what. It's really about planning ahead and writing down what both your expectations are so that you understand and there's no surprise later. Everybody's on the same page. Everybody knows what's going on. So let's say that Jason and I are working together on a presentation or a handbook for small business owners. We're both contributing. It's going to be a joint work. One question might be, well, Jason works for the DC Bar. Is his expectation that I'm doing this work for the DC Bar and he's going to post it to the DC Bar website and I'm not going to run off and do other things with it? Or is the expectation that both of us can use it, that I can use it to do client development and reach out to potential new clients for myself and rebrand it with my firm website and use it for other purposes? And again, this is one of those situations where you can see if we haven't talked about that up front, we could have very different expectations about what's going to happen with that work after we're done creating it. One common question, especially if you're in the nonprofit realm, depending on who you're working with, can I use this for paid or commercial purposes? Can I license it to other people for paid or commercial purposes? And if that happens, are we going to share the revenue from that? And how would we share it? Once the work is prepared, who can translate it, modify it, produce derivative works from it, right? Can I use pieces of this and plug it into something else? And if I do, am I going to attribute the new work to Jason, who may or may not have seen it or had anything to do with it? So again, getting clear on, once we have the shared work, how are you going to use it? What are you going to do with it? How are you going to distribute it? Are there geographic limitations? Should rights expire? If you had a collaboration in the 1980s, the humor there may not come across the same way today as it did in the 1980s. The cultural references might not work anymore. The materials may go stale. If you're working on public health information, you know, our understanding of epidemiology, our understanding of disease, our treatment options all change. Are you going to be frustrated, angry if your partner is distributing outdated materials sometime later? And maybe the 1980s feels like an extreme example, but if you look around the internet, you can find some things that are pretty out of date, even on the internet, which doesn't really fully go back to the 1980s. So thinking about what are we going to do? Is there a time period where this is going to stop and we all agree that we'll either get together and review the materials or we'll stop using them? Whether it's for profit or not, can I take the joint work and sub-license it to others? Do I need to come back and check with my collaboration partners or with my consortium on whether they're happy to have these materials, which may include their logos or their information being associated with other groups? And do we need a process for doing that? And then are we going to register any IP rights in the joint works, and who's going to do that and who's going to bear the cost of that? So whether it's a copyright registration or we're going to trademark a name for the consortium or take out domain names, who's going to do that? Will they check in with the group? Whose name are they going to be registered under? All of those things. And that can also save you costs as opposed to all of you running out and trying to independently do it and then ending up with a bunch of unnecessary duplicative work. So it's not so much an adversarial conversation, it's just setting expectations and making sure everybody understands what page you're on. Similarly, if we're all working on something, right, if everyone's responsible for it, no one's responsible for it, I'm sure you've heard that before. Who's responsible for actually making sure that we're making progress? We're going to have a big meeting. There's going to be 5 of us all talking about the same public health issue. Who is actually responsible for calling those meetings, for making sure follow-up happens, for doing the drafting, for registering the IP? Is there a time frame when we need this to be done? If you're operating under a grant or you have some other stakeholder or there's some time sensitivity to the work, making sure that we've all agreed on that time frame, because again, we may have different stakeholders or different influences. I may think this absolutely urgently needs to be done within the next 30 to 60 days. You may think we have a year and a half to finish it. So just having these conversations up front. When a draft is prepared, who gets to review them? If somebody has comments on the work, is the original drafter obligated to incorporate those comments? Are they encouraged? Can they ignore them and move forward? How are we going to share decision-making responsibility and review of the published work? And then, of course, we want to be very careful about the rights to use our name or logo or our background IP, anything taken off of our website. We want to make sure we have review rights before those things are incorporated. And we want to make sure that we've also talked about, again, issues like, is this going to go stale? How long can you use this? Can you use this in other contexts? Excellent. An important point that we don't always pay attention to is that you can enter into an agreement without realizing it. We do a lot of our work on websites now where we order things without even thinking about it. But those websites almost always have terms of service or terms and conditions attached that set rules for the purchases. As a practical matter, if I tried to read all of the privacy policies and terms of service and terms and conditions for every app I use and every purchase that I make online, that's all I would do. I wouldn't shower, I wouldn't eat, I wouldn't sleep. All I would do is read through these form agreements, which can be really long and outrageously cumbersome. So for low risk transactions, it's probably fine for you to just order your office supplies from Amazon or Office Depot or Target without running down the terms and conditions and reviewing them in detail, right? You're ordering off-the-shelf items. There's nothing made to your specs. There's nothing custom about the product, right? I just need sticky notes and some blue ink pens, please. The cost is relatively low, right? So if something goes wrong, it may be frustrating. It might even be bad, but it's not going to be catastrophic. Again, if something goes wrong, you could cover. There's someplace else you can run down to the store and get sticky notes, and maybe they won't be at as good a price, but I'm not going to be without whatever it is that I need. Maybe it's packaging materials so that you can ship out goods. You could easily run to Walmart and buy envelopes or whatever to keep you going for a day or two until you can get replacement goods. So assuming you could probably buy sufficient replacement goods, if you have gotten your operation to a size where you could not easily buy replacement goods, you see that this starts to become a little bit more important for you to understand what the terms are for when your product's going to arrive, what will happen if sufficient quantities don't show up, what will happen if the product is defective. All of a sudden, those things become more important if the failure of this deal would be really catastrophic to the business. It would shut you down for a few days. It would cause some kind of horrible reputational harm. If there are regulatory concerns, if you're in any kind of regulated industry, you want to make sure that you're dealing with any of those obligations. And of course, if I have to provide you with any kind of confidential or sensitive information, I want to know what the conditions are for that. Is there any kind of confidentiality protection? So for higher risk transactions, you want to find and understand the terms that are offered. And if they're unacceptable to you, you want to reach out to someone and negotiate for your supply or for your arrangement, as opposed to relying on those terms and conditions. So it's just not practical to negotiate for everything you do, but you really do want to be mindful if this is really a critical deal, or if I'm sharing very sensitive information. For example, my customer list, you're going to drop ship whatever I'm having prepared. And so I'm sharing my entire customer list with you. You want some assurances that that information is going to be stored securely and handled on a confidential basis. Okay. I have a couple slides here about basically reading through agreements, making sure that you can meet the obligations that you're committing to, making sure that you're getting back from the other party exactly what you need, whether that's a report or the actual logo from a graphic designer or a functional website from the programmer. The key point here is if you sign or check an I agree box or a click through box, you will likely be held to the terms of that agreement, even if you never read it, even if you didn't understand it. So it's really important if someone sends you an agreement, or if you're purchasing things under terms and conditions on a higher risk deal, that you've actually looked and you understand, because I didn't understand that in most states is not a defense. You'll be held to the terms of the contract. I didn't read that is not a defense to the terms of the contract. So make sure you've read it and you understood it. If you have questions, you schedule a call with counsel. That's what you do. If I don't understand what the provision is doing, if I don't understand why this provision is in this agreement, if it's obligating me to conform to the laws in Japan and I don't know why that's relevant, or if I can conform to those laws, you call an attorney and you schedule a consultation. My sense is that that's almost always avoided for cost. So I want to take the last few minutes and talk about how you get legal advice when you have no budget. So one thing is, please pay attention to your lawyer's engagement letter. Different lawyers and different firms have different billing practices, everything from, am I billing by a 1/10 of an hour or a 1/4 of an hour? How often will I bill you? Will I bill you once a month or once a quarter? Do I expect you to prepay or file a retainer? So understand your lawyer's billing practices. And if you don't understand, or if you have any kinds of questions, you should ask. And I'm going to say, if you don't feel comfortable asking, you need to stop and find a different lawyer. It is absolutely essential that you feel comfortable talking to your lawyer and asking questions even if they make you feel stupid or uneducated, because that's what your lawyer is there for. A really good lawyer is supposed to help you through all of that so that you feel confident and empowered and can go on with your business in a really confident way. So if you're not comfortable having this conversation with this lawyer, I'd encourage you to find a different lawyer. There are lots and lots of us. We have different styles, we have different preferences, we have different billing practices, so ask around. When you're preparing to meet with your lawyer, gather the information that your lawyer can't gather for you, right? So when you call me, I know a great deal about intellectual property law and how it works and how this plays out in agreements. What I don't know is what agreements you've already signed with this counterparty. What I don't know is what the scope of the work that you want to do together is. So if you Google the legal issues and come into my office, and we're both trying to talk through the legal issues, but we can't decide on which laws are actually applicable to you because we don't have copies of the prior agreements, and you didn't remember to bring a copy of the scope document. That means we have to schedule another appointment to go through and actually do it. So let your lawyer, if you're going to pay a lawyer, let your lawyer do the lawyering. Make sure you're bringing the business information and all of the background documents that will help your lawyer actually concretely answer questions for you instead of saying it depends, which is really not a good use of your dollars. If you're on a tight budget, many times when we're talking to attorneys, we're talking about something that is emotionally triggering for us. We're very excited about an adoption or getting married and writing a prenup, or we're really scared because our dog bit somebody and we're afraid we're going to get sued, or we're mad that someone else has started using our new business's trademark or sent us a cease and desist letter when their company is terrible and yours is great. If you come into my office highly emotional, we can talk through that. You can complain about the counterparty. That's probably not the best use of your legal spend. So think about, do you want to take a walk? Do you want to phone a friend? Do you want to try to work through some of that so that when you come into the legal office, you can really maximize your time with the lawyer and focus on the legal issues? The other way I see strong emotions manifest is people who come in and they just want to sue. They want to scorch the earth and hurt people. And it's because you haven't worked through the emotions yet. That's not unique to you, it's human. But if you set us down a path where we're going scorched earth, it can be very hard to come back. It can be very hard to make good decisions when you're emotionally worked up, happy or sad. So working through that a little bit before you come into your lawyer's office will again help you just use that time that you're paying for with your lawyer as productively as possible. And then again, coming back to, you should have a good relationship with your lawyer. Talk to your lawyer about your relationship, about your utilization, about what kinds of work you're bringing them. Ask them if they have recommendations for you, because they may be able to give you tips and say, well, what I'm seeing is this kind of pattern, and I think we could work more efficiently together if we did this instead. Or I'd like to bring in a younger associate at the firm who bills at a lower rate, but I'll stay in touch and I'll be available for consultation. So if you ask, they may be able to make recommendations on how to save money. And then finally, if you need to find a lawyer, consider finding a lawyer who you like, who you can work with regularly, so that when you're meeting with them, you're not over and over explaining your organization and the project. Having that background is very helpful. It means that we don't have to ask you the same questions over and over again, and so it is over time more efficient. You can look for help from local bar associations or legal aid providers. Law schools may have clinics or practicums. American, George Washington, and George Mason all have clinics in the DC area where you can consult with a law student who's supervised by a licensed attorney. And sometimes business schools or economic development organizations will have clinics or the opportunity to sign up for information or consultation with an attorney for free or reduced cost. This is the website that Jason read to you at the start of the program. This is the DC Bar's sort of first stop for nonprofit and entrepreneurs looking for legal assistance. And I will pitch that there's a small business legal clinic coming up through the DC Bar on September 28th. So if you click through to this website, you can sign up for a consultation with a lawyer as part of that clinic. And there are other ones coming up in October as well. I think that's as far as they're scheduled out right now, but that is a great place to get help if you want help with a specific question. And with that, I think we are at or over time. So I'll stop. I will stay on and answer questions if anyone has any. Otherwise, thank you so much for coming. I hope this was helpful, and please do check out the DC Bar website. It's a wealth of information.
Thank you so much, Amy. This bit at the end about how to work with a lawyer and when to consult with one is such useful information and not something that we have a lot of resources on. So that's amazing to have this in the presentation. And yes, thank you for flagging our Law Help website at the bottom there, where we have our archived educational resources and then also links, as Amy mentioned, to upcoming events and our rolling brief advice services, including our monthly small business clinics and our nonprofit office hours. With that, since we are a little bit over time, I'd like to wrap it up. And just finally, one more thank you to Amy Foust for joining us from Wilson Sonsini to talk about IP, to talk about sharing and transferring intellectual property, and all the other great advice that Amy shared with us today. Thanks again, Amy.
Thank you. Bye.
Take care, everyone. Bye.